Thanks, Tom. I'd like to welcome our panel. Is everybody mic'd up? I think so. Great. So we've asked Douglas Pepe, a partner at Joseph Haig Aronson, to moderate the panel. He's not a cyber guy. He's an attorney, a litigator. And we did that on purpose. We want to create a dynamic where we're asking poignant questions that are geared for lay people. So please welcome our panel. Includes Doug Pepe, Michael Richter, he's an associate of complex litigation and trials at Skadden. Andrew Silberstein, the director of cybersecurity at BDO. Eric Feldman, the CIO at the Riverside Company. And Robert Picard, CEO and founder of the Rumson Ridge Group. Thank you. Thank you, gentlemen.
Okay. So we'll try to, it's the doldrums of the afternoon, so we'll try to bring your energy level up. My name is Doug Pepe. As Mike said, I'm a litigator here in New York. I am not a cybersecurity expert. What I am is a commercial litigator. And that's important for purposes of this discussion because I am the guy that you do not want to be calling with the words cybersecurity coming out of your mouth. What you want to do is you want to listen to the people like the experts on this panel and the people we've heard from previously so that you never get to me. I'm the last defense and you don't want to be calling me. So with that introduction, I'd like each of the panel members to tell you a little bit about themselves, tell you a little bit about their expertise, and we'll get into the topic.
Sure. My name's Mike Richter. I'm an attorney at Skadden. I actually used to work with Doug. I'm also a litigator. And I also focus on cyber. Before I was a litigator, I was an intelligence officer for about a decade with the Office of the Director of National Intelligence and the Defense Intelligence Agency.
My name is Andy Silberstein. I'm a director of cybersecurity at BDO. I help support and lead a team that does various kinds of cybersecurity services. These include vulnerability and penetration testing, data leakage prevention, assessments, social engineering, phishing campaigns, and something that we've heard in the past few talks, managed detection and response.
My name is Robert Picard. Thanks to Tetherview for having us today. I have built 3 separate, distinct, multi-billion-dollar hedge fund and private equity platforms. I've performed due diligence on over 1,000 hedge fund and asset management firms and managed money for state pension funds, in financial institutions all over the world, and high net worth individuals.
I'm Eric Feldman. I'm the Chief Information Officer for the Riverside Company. Riverside is a global middle market private equity firm. I'm responsible for all things technology related for Riverside, and one of those buckets is cyber risk management, not only for the management company, but also for our 80-plus portfolio companies.
Okay, so one of the things I'd like to do is break our discussion up into 3 time periods associated with a cyber attack. Before the attack happens, during the attack, and the after action, what happens after the attack, and what are you supposed to do? So let's start with before, and the question, I'll throw it out to any panel member who wants to answer it first, and we should go around the horn. These are private equity companies. They have significant portfolio companies under them. What are these organizations supposed to be doing prior to suffering a cyber breach, to prevent the cyber breach, to analyze the threat, to understand their technology? What would you do? What would you advise them to do?
So I'll just start. From a legal perspective, your portfolio companies, need to be thinking about how can I minimize a litigation risk that were it to occur, you'll have to call Doug. And one of the ways to do that is you do have to engage these types of services like Tetherview and BDO to do a war game or a tabletop. I'm more fond of calling it a war game only because I used to do war games at the Pentagon, but a tabletop to identify where your vulnerabilities are. And there's a couple of legal reasons why to do that. And just to give some color around it and just some background, having done these for clients in the past, one thing you don't want to do is have a document that says, make sure you copy your general counsel on every single communication related to this so that it stays privileged. That is a guarantee that it will not be privileged. That's the first paper that your adversary will bring before the judge to try and invalidate any cloak of privilege. And when you do these war games, you're typically going to get an after-action report telling you where your vulnerabilities are. That's the document. If I'm plaintiff's counsel, I want that document. I want to show that look at all these things, you knew you had a problem and you did nothing.
And I should tell you from a litigator's perspective, this is one of the most important things that you can take away from this. As a litigator, what I look to are what was promised and what was delivered.
Yep.
And I think one of the prior speakers spoke about this issue. Mike hits the nail on the head with this. From a litigation perspective, having a report that says this is what you should have done and not doing it is your worst case scenario.
Right.
Right. So from a technology or risk management perspective, it's really all about being prepared and being prepared for complexity. Today, it's really about the frequency, which is increasing significantly, and the sophistication of the attacks. So what that means is be prepared for something that's complex, and be prepared for the unexpected. There are things that we do know from the experience that we've had, and there are what they call attack vectors that are being developed that will surprise us. So being ready for the unexpected. And what does that mean from a technology and a risk management standpoint? It means have the kind of resilience in your organization so that when something happens, you know where to go. You know the technology is identifying where the problem is, and essentially, to simplify, where do you press the kill switch? Something is in your organization, you didn't really know where it's coming from. Where do you press that kill switch? And how do you get your organization understanding what to do? How do you contact your legal counsel and what to do next?
So I'll follow up on that. From a due diligence perspective, so I've met with a number of companies, and it's absolutely fascinating where for the past 10, 15 years, banks, certain hedge funds and private equity firms have these wonderful computer-based cartoon systems, compliance systems. To be compliant, you have to follow through this cartoon and basically answer questions as it relates to money laundering, learning about money laundering, how that works. Clearly, they've been operating this for 10 to 15 years. We've all been through this training. Nonetheless, there's still obviously significant money laundering going on in the world. We just had a bunch of discoveries, whether it be Danske Bank recently, a number of other banks who've had billions of dollars of money laundering going on. I have yet to see that beautiful cartoon appear for cybersecurity, for instance. So when you talk about risk management, and I deal mainly with hedge fund firms and private equity firms, and performing the due diligence, you realize that it's the traders, the portfolio managers are typically not necessarily owners, and they look at it as, oh, it's the IT guy's problem. Oh, we've got that IT guy in the back of the room. He's got it covered. He's doing the patching. But the reality is they are dealing with phishing. They need to know what phishing is. Obviously now, since the most recent election, I think it's become more, people have become more aware. But phishing is getting much more sophisticated. They're having to deal with USB ports. Anyone who's familiar with what Stuxnet was in Iran and elsewhere, you think that your network is secure, but anytime you let someone into your company through those doors, they could do something that could be dormant on your servers. And I'm dealing with hedge fund firms, then you go into the risks of trading inaccuracies, trading breaks, flash crashes, any number of things that could occur that really have not yet been fully vetted and identified, but these are things that you have to think about. I always look at, my career was very simple when I just had to think about how's a trader going to cheat. I spent a lot of my time thinking about how do these people cheat, and I'd figure out different ways that they'd go about it and then put in place systems to stop that. We've basically taken the goalpost and moved it from one stadium to another stadium because now we have to think about, okay, how's a hacker going to attack us and how could they attack us? And we just added this entire exponential opportunity. So the risk is there. When you talk about what to do beforehand, is really think about how would they do this, and are my personnel properly informed about those risks?
Yeah, I think your point is spot on. Riverside thinks about cyber, and Michael from BDO mentioned it earlier. Cybersecurity, that term, it's relevant, but it's really adding cyber to the conversation of the overall risk management strategy for the firm. So for Riverside, we have a pretty broad portfolio of lower middle market companies. So limited resources, limited sophistication. we've tried to encourage our companies to think about cyber in different ways. First and foremost, we have really pushed educating our companies about what the risks are for lower middle market companies. And within the companies, again, have encouraged them to develop actionable policies that can be enforced, how to educate their employees around what the risks are. For most of our companies, it's coming through email, which has been discussed by the other speakers. The other areas that we focus on are both technical controls and administrative controls. The companies we invest in don't have an unlimited amount of resources financially. So we provide advisory services. We actually develop a group called the Riverside Information Security Office. We've partnered with a number of third parties. When we acquire a company, even before we acquire a company during diligence, we are doing some level of cyber risk evaluation. But after the acquisition, we've developed a criteria based on 19 distinct categories, and every single one of our portfolio companies goes through a 90-minute interview, and throughout our entire hold period, we're going back to that baseline, and we're seeing what risks have been introduced as a result of an add-on, of a loss of a key member of the management team, new products, and we've also built a community across our 80-plus IT leaders. So it's a knowledge-sharing environment where people can ask questions. We've also leveraged our buying power with some of the technical solutions that are out there. So for companies that are interested in a web content filter or some type of email management system, they're able to leverage this pooled purchasing, what we call the Riverside Toolkit. So they're able to leverage that to help drive down the costs. But it's really about making sure the employees understand that they are, within our portfolio companies, that they are the first line of defense. Because quite frankly, as I mentioned, our companies don't necessarily have the resources to go hog wild and spend hundreds of thousands of dollars on pure technical controls.
Another thing that often comes up when you're thinking about it ahead of time is you have to be reasonable. And that's sort of the go-to word. And what clients always ask and should ask is, well, what does that mean for my organization? How do I determine if I'm acting reasonably to mitigate an event? And that's a very challenging question to answer, and I can give it to you in extremely broad strokes. There's a case from several years ago called FTC v. Wyndham from the Third Circuit, where Wyndham had very bad security, and the court went to great lengths to point it out. And then you have, I would say, the NSA, which is the gold standard, and which has also been breached. So you have to be better than Wyndham Hotels and not as good as the NSA. There's a lot in between those two extremes. And so what it really requires is sort of an independent assessment. Are you regulated? How much PII do you have? You know, if you're an air conditioner manufacturer versus a data aggregator, that's going to change the dynamic about what's reasonable. What has your regulator said? You know, are you at a place where you do need to be buying cyber threat intelligence, or if you're doing, you know, gross revenue of $10 million a year, maybe that's an investment that's not really necessary. So this is a very sort of individualized assessment. And, you know, I've heard a lot of numbers today going around about how big breaches are. Well, there was a lawsuit filed just a few months ago in the Middle District of Florida against a data aggregator called Exactus. And according to the complaint, it alleges that the breach is bigger than Equifax. It alleges 250 million records have been penetrated. So,
incredible. So you've done your wargaming, you've done your risk analysis, you've got your systems in place, but one of them slips through. You've got a breach on the order of Equifax, a breach on the order of Sony. What is the first thing you do when the IT person comes to the CEO and says, we had a breach? What do you do? Mike?
sure. I mean, well, you should have things ready to go, like the data breach notification document that you need to send out to affected persons. Every single state in the United States now has a data breach notification statute. Because these events are generally national or international, you're generally going to be applying, you know, the highest standard, which has the shortest period and the most amount of information you have to disclose. Right now it's Colorado. In a few years it should be California, which just passed a new law that's coming into effect in 2020. That document should basically be ready to go so that you can just plug some things in. You need to get recovery people in. You need to get your lawyers in. And I always say, having your lawyer meet your recovery people at the moment of the event, that's not a good way to get started.
Right. So, just following up on that, having an incident response plan, which is really what we're hearing about, is critical. And an incident response plan covers a lot of different areas. So what happens when that incident happens, when there is a data breach? First, there's that immediate need to find out what technically was breached. And that gets back to my point about where's the kill switch. What part of the network segment was attacked? What part of the database, perhaps that you have critical information or PII information, and make sure that you segment that, secure that off. That's really an IT function. That's kind of a very tactical, here's what you do as soon as something happens. And having a plan in your IT group that understands, and one would think, and I think it was mentioned, we rely on our IT groups for many, many things, and we make an assumption that they're taking care of us. And in some cases they do, in some cases they do okay, and in some cases they're very good at it. But in the middle, it could be that there's a breach and the IT folks may not have a plan in place that understands what to do in the event of a particular breach of that data coming out. So it's important to have the IT group have that technical piece of what to do in the case of an incident. Then obviously there is the organizational piece, which we heard a little about. You do need to get in touch with the senior management in the company, with the counsel, with your legal counsel, to understand here's what the implications are to both the employees inside the company, the customers, and anything that might have gotten out. So I would say it's very much a multi-layered response, but having something that's clearly in place and having your employees understand what that means. And that goes beyond just, okay, the IT group understands what needs to happen, or one or two people. There needs to be an awareness, a cybersecurity awareness that here's what we do in the event of a data breach. And back to more of a technical piece, it's important that there are things in place on more of a business continuity basis. Do you have a business continuity plan that you engage in the event of a security breach? So what has been breached? What can you back up? Was it a ransomware? In which case you do need to have, and hopefully you have things backed up. So again, I would frame it more as there's the technical layer that the IT group needs to take care of, and the organizational layer that is just as important to make sure that the organization is aware, the legal counsel takes the right actions going forward.
What about public relations?
So it goes back to some of what was said, which was, is the awareness. And you mentioned gaming or war gaming a situation. My experience having met with a lot of my money managers and others is the larger firms are obviously much more well-versed, so they generally have not on staff, some have on staff, but some have already contracted with third-party PR firms who are extremely well-versed in crisis management and dealing with these situations. They obviously, one of the first calls is to counsel, to make sure that they initiate and start with letters and proper procedures and policies. But the reality is, if you look at the world of 9,000 hedge fund firms and all the asset management mutual fund firms and private equity firms, realize most of them are not large enough to really have that support in place. And invariably, it's just, unfortunately, they're just not equipped to deal with it. And that's something that goes back to potential risks down the road that invariably are going to happen. And it comes back to trust in that industry, trust in those managers, and invariably will probably continue with what we've seen over the last 5 to 10 years of money flowing to the much larger money managers at the expense of much smaller firms who just don't have the ability to compete in those layers. But there are great PR firms who deal with this on a daily basis.
And just to comment on that, you should assume that every single public statement you make will be looked at by a litigator like Doug, and he will look at it to see if he can use it against you somehow. Is that
Or
fair?
use it to defend you?
Or use it to defend you.
Yeah, I mean, just to follow up and to cheat a little bit, I'm going to go back to how do we prepare. Again, thinking of the ecosystem of rather small, unsophisticated companies, one of the other areas that we talk to our companies about is incident preparedness, not just response. And our companies aren't staffed to have a full-time CISO that will help develop this. Quite frankly, the CEO is overstretched, to put it mildly, and the CFOs as well. So we talk about sort of right-sized things that our companies need to be doing. It really goes back to educating them. And so in the event of an issue within a Riverside company, companies are instructed to lay off email and not be chatting about it so much. We've developed a partnership with a multinational law firm where we have a cybersecurity hotline. So in coordination with an operating team member who's a Riverside employee, they'll reach out to this hotline and have an initial conversation about it. Most of our companies, they have cyber liability insurance. I know we've talked about some of the pros and cons of it, but what I've seen as a real pro is a panel of experts. Our companies today, for the most part, don't have a big forensic firm on retention, but the cyber liability policies, they provide the PR, the attorneys, the forensic work, and it's been really beneficial for a number of our companies that have had to deal with an incident. So for us, it's manage the communication, try not to rely so much on email and discussing it, pull in counsel to provide a path forward, and more than likely exercise that policy so we can get the right professionals in to help do the forensic deep dive and provide additional PR or legal counsel.
And during a breach, when is the right time, Mike, this is probably a question more directed to you, when is the right time to start reaching out to regulators, if you're in a regulated industry, or the FBI in any industry?
So, I mean, the answer is generally probably right away, but you do need to be thoughtful about it. I mean, you have to imagine a circumstance where later on, if you are in a lawsuit or a dispute, that, you know, once you've shared information with the FBI, that there can be an effort to gather all that information. So generally, I think the answer is you want to be open and disclosive because they do treat you as a victim, and generally, especially the FBI, they are trying to help you, but you do need to be careful. And so it's kind of like a Wells notice is when the SEC gives you an opportunity to tell them why they shouldn't come after you, but anything you tell them, if they choose to come after you later, they can use it. And so I think that needs to be in the back of your mind as well.
Any other thoughts from the non-lawyers on the panel on regulatory issues? When's the right time to talk to regulators?
I would just say, having been as somebody that ran a large managed service group about 15 years ago and was a victim of a advanced persistent threat cyber attack from a foreign adversary, actually from the Chinese, I think notifying the authorities, and particularly the FBI, sooner than later is the right thing to do. That was the experience that I had. That's the experience I think that a lot of companies have. So I think err on the side of identifying it sooner than later and reaching out sooner than later to regulators.
I would think, though, especially if there's smaller firms here, but really have a connection with either your general counsel, and if they're not an expert in these kinds of things, particularly now with GDPR and data privacy, really build a relationship with an external firm that could advise you rather quickly on what those requirements are. Because as I think you mentioned, every state has a notification, different notification laws, and across the world, there's not a lot of consistency. So without that kind of legal advice, you could jeopardize potentially yourselves or your portfolio company.
So you've had the assessment, you've had the breach, now we're post-breach. What do you do? After action, what do you do to clean up the mess? What do you do to fix it so it doesn't happen next time?
Right. So I think part of the answer to that is to understand what the threat is, because the threat today is not the threat necessarily tomorrow. And understanding, you know, where the trends are in the cyber attacks, I think, is a critical component, because that then drives what kind of technology, what kind of policies, and what kind of cybersecurity awareness you're going to bring into your particular organization. And I think staying current with that, or having people in your organization that stay current with the trends and then communicate those trends, is really critical to, okay, here's after the breach, now what do we need to do to make sure that we secure ourselves, we improve our security posture for the next time? You know, something that we do at BDO is every quarter we have our own threat intelligence group. They are out there constantly, diligently looking at what is happening. We do put out a quarterly report, and it's actually available to the public, and it's, I think, quite useful and insightful. And this group is always out there, always looking for what's happening, more from a trend standpoint that can be translated in, okay, how do you prepare for the next potential breach? So I think, yes, do some forensics on yourselves on what happened to make sure that that particular event doesn't happen again, but have that perhaps be the event that raises the awareness to look forward, to look at trends, and to make sure that perhaps what was not in your organization, again, whether it's from a technology or an awareness or training standpoint or policy standpoint, does get brought into your organization.
I would just add on to that, that I think the focus should really be, we all tend just emotionally to be reactive to situations, and I think in that situation you kind of have to flip from being reactive to immediately becoming very proactive, and to a certain degree getting a third party to audit. Just not only, I'm sure the outside counsel would approve of that view, but I think you really want to get a third party to audit it, to be much more proactive as to what went wrong post-mortem, and then most importantly, what in the future could go wrong, and demonstrate clearly to your investors, provided the breach wasn't something that was lethal and or ultimately killed the company, prove to your investors that this was an exceptional situation, and that going forward you've put in place the process and policies to make sure that doesn't happen ever again.
Yeah, no, I agree, and I think it goes back to sort of how to prepare. So having an independent, reliable, trustworthy third party doing a continuous evaluation of your entire ecosystem every year, every other year. But that certainly is an opportunity if there is an incident to talk to upper management and take advantage of that if they had been resistant to paying for a service such as that. And then it's really taking that information, developing a remediation strategy, risk ranking some of the points that are found. And again, it really does go back to the human being the biggest risk factor here and continuing to focus on educating the employees.
One thing I'd like to say what you shouldn't do. Don't hack back. It is illegal still. It's against the law. I know a lot of companies sometimes want to hack back because they're upset, and there have been great examples where hacking back would seem very, very reasonable. An example that comes to mind without naming any entities is it was a West Coast company. They got to the office in the morning, realized that their data had been stolen. The data was sitting in a server somewhere in Asia, and it was, in a few hours they could determine it was going to be moved to another country, which was responsible for that attack. And if they acted now, they could have pulled their data back. And without responding to whether or not they did it, it is illegal to hack back. So don't hack back unless the law changes, and then we have to reassess. But I think the other thing to talk about is what kind of lawsuits can you expect? You can expect regulatory actions.
Shareholder suits.
You can expect shareholder suits, class action suits.
If there's insider trading involved, like there was previously discussed with the Equifax breach, you can have criminal actions.
Right, exactly. But there is one little silver lining, I'll say, which is there is currently a circuit split in the United States. So half of the circuits right now say, in order for there to be standing, in order to have the right to come in front of the court and say that you have a damage and you've been harmed, you have to show that you really had a specific loss. And that means like money has come out of your pocket, right? The fact that someone maybe stole my social security number, that's not enough. Or maybe the fact that they opened a credit card, that's not enough either if the credit card company reimbursed me. And so sometimes you're seeing allegations and complaints that are trying to deal with that problem, saying, well, I had to buy credit monitoring. Well, credit monitoring you can get for free from a lot of places now. So you've got about half the circuits in the country saying, if your private information has been stolen, that's enough, and the other half saying it's not enough. So kind of a silver lining, but we should expect that plaintiffs' lawyers will be going to those jurisdictions.
Sure, and you need to cabin your exposure. For example, if you're a supplier and you get hacked, like in several of the breaches, like Target, it was associated with the POS machines. If you're a supplier of a piece of equipment and you get hacked, that hack can be much larger than your organization. When it's an organization like Target you're dealing with, or a major company, so there's a significant litigation exposure, and I think that from the perspective of a litigator, what I want to see is wargaming, I want to see tabletop exercises, I want to see risk analysis, and I want to see follow-through on all of those things so that I can defend the litigation that you weren't unreasonable in the context of a tort suit, that you took appropriate steps in the context of a securities case, that you did not make any misstatements about your tech or your security in the context of a shareholder suit. These are all very, very important things.
You know, on the wargaming thing, I want to talk about that report for a little bit more, if I could.
Sure.
You know, you could have a wargame after-action report, and it could list, 10 different things you ought to do if you wanted to get to, I think what one of our earlier speakers said was like that perfect security. But there's no way you're going to do numbers 8, 9, and 10. It's too expensive. It's not worth the, pros and cons. It's just not worth it. But now you put it onto the document, and you made a decision not to do it. Well, I mean, if I'm going after you, I don't really care that you made a decision not to do it. I'm going to try and make an issue out of that. So, I mean, I guess what I'm trying to say is you want to think about sort of the legal consequence about what is going into that report, and to the extent you can, cloak it in privilege if necessary, because you're going to be making business decisions about how much money you're going to spend on enacting those policies.
Yeah, one of the things we encourage our companies to do, particularly if they're engaging a third party to do this risk assessment, is to actually do that through counsel. Mm-hmm. So that agreement, probably not surprising to anybody, but that contract would be between the law firm and the third party, and all of that, I guess I'm learning not everything is necessarily privileged, but that's at least a recommended step that we've been doing for a few years.
Right, it's not a guarantee, right? Because facts, I mean, and Doug can tell you this better than I can, facts are not going to be privileged. So you might try and engage counsel to do that, and, hopefully you'll be successful at it, but it's not 100%.
It's a substantial issue in every serious litigation where there is some pre-action study or analysis of a product or security issues. It's a major issue. It's been the issue in the tobacco litigations for many, many years. Mike is entirely correct. There are significant issues, and you have to be very careful when you're doing an analysis of this nature of what the litigation risk can be if you don't implement everything in that analysis.
Yeah.
So we've talked about sort of the before, during, and after of an actual attack, but the topic of our discussion is threat forecast and threat assessment. We've got a little bit of time. Why don't we, and I think, Andy, you're probably the best person to address this. Why don't we talk a little bit about what the current threat environment is, and what are the major, let's say, 3, 4, 5 risks that PE shops and their portfolio companies should be looking after?
Sure. So when I looked at this, the topic threat forecasting, particularly the concept of forecasting, it kind of brought me back to my days when I lived in Asia, and specifically in Hong Kong and China. And when you live there, wonderful culture, you're exposed to many of the ancient sayings. And one of the sayings as it relates to forecasting is, those with knowledge don't predict, those that predict have no knowledge. Now, so that's a tough way to start this conversation.
I'm glad I asked you that question then.
But I would say that was in the 6th century. So that particular philosopher did not have the advantage of data, science, technology, and all the statistics today. And I would say that what we have today are truly the trends that we can look at. And it is truly the trends that are taking all the statistics that we've been living with. And they really do change. So when we look at just the last 6 months, maybe 6, 9 months, one of the significant things, particularly in the financial industry, has been this crypto coin rush, right? There's been a tremendous amount of things going on in that particular arena, and it was like a meteoric rise and essentially a crash now, right? It's really down. So how does that relate to today and the trends? I would say it sets the stage for the trends that we're looking at today. And what I mean by that is the crypto adversaries, those bad guys that are going out there, took advantage over the last 6 to 9 months, and they did a lot in terms of hacking into platforms, crypto platforms, whether it's Ethereum or Bitcoin and the like. They made a lot of money. So what does that mean? They have a lot of new funds, they got a lot of new experience, and they got a lot of new tools. What they find today is that there's not a lot of activity there, so they're now going back to more traditional means of the attack vectors. And what are those? We heard about it this morning, ransomware. We are going to continue to see a rise in ransomware. It's traditional, but those bad guys, those adversaries say that is a very effective way to make money, to get financial gain. There's another new area which they're now calling business email compromise, or BEC. And business email compromise is not just, and really specifically not necessarily email phishing. What they're saying is it's sort of the sophistication through simplicity. And the adversaries are out there simply collecting data on the right people in an organization. So there were specific examples, and the FBI has actually listed this as one of the significant means of money transfer among the adversaries. They come into an organization, they find out who is in accounting, they find out specific companies that may be on accounts receivable, they find out what the banking accounts are, and they can do this without malicious emails. They can do this not necessarily with planting something, they can do it through phone calls, they can do it just through surfing the web and doing their own intel. And there are examples of emails going into accounting. It says, I am company X, I do business with you. My old account number was this, and it's correct, and something has not been paid. I need you to give me a wire transfer to a new account. Now, typically, somebody in accounts payable is saying, look, if it's a new account, I'm not doing this unless I have information. However, if you're giving them the old account, that's already something, wow, okay, it's a company I know, it's a name that I know, they actually find out the names of the people, so they know the name, they know the account, they go ahead and they pay them. This is a significant trend now. So, you know, this BEC, or this business email compromise, together with ransomware, is pretty significant, and it's a trend that we're probably going to start seeing more and more of. I would just say the last trend, and this is a disturbing one, not exactly technology-based, but it's happening today, and it is essentially the behavior, the information security behavior within organizations, companies, and even individuals is actually on the decline, which is completely counterintuitive, right? With everything going on around, with all what you hear about in the media, with everything that you see and hear in these kind of discussions, you would think people would actually just be doing more. The opposite is happening. And the belief is, it's more organizational or behavioral, that there is fatigue setting in. Because with the advent of all these connected devices, in the house, outside the house, the billions of Internet of Things devices, people say, look, my information is going to be out there. They are constantly barraged with the information of hacks that are happening online. And with all of that, there's a belief that this fatigue now is actually lowering the level of information security across companies, organizations, and individuals. So I would say from a kind of a threat forecast standpoint, I would say those three things are something to keep in mind. Again, the business email compromise, ransomware, and now being aware that right now the information security is actually on the decline in terms of awareness.
So I'm a big fan of primacy and recency, and I'm a fan of takeaways. So I'd like each panel member to take the last 2 minutes that we have to give these folks in the audience your 1 or 2 key takeaways that they should be taking out of this conference and thinking about when they get back to their organizations. My takeaway is very simple. An ounce of prevention is worth a pound of cure.
Yeah, I mean, I would agree 100% of that with just one caveat, which is, you know, having done so much war planning and war gaming in the Pentagon and what we called IPB, intel preparation of the battlefield, it's good, it's essential, and you should do it. And then when the event happens, nothing ever goes exactly according to the plan or to the preparation that you've undertaken. And so I think the most important part of it is having a really good team in place that you're comfortable with. And that's why getting the team at the last second when the event occurs is just going to make it worse.
I would say risk management equals being prepared, and being prepared for the unexpected, and making sure that your organization both has the security infrastructure, which is really technology, as well as the organizational framework to handle that event that is eventually going to happen.
It's like absolutely nothing is secure. I was similar to yourself. I was in the military, and we used to, in M109 artillery tanks, and we used to always figure out, you know, we'd always game it if our radios went down. We're talking obviously 20, 30 years ago when we were dealing with radios, giving us vectors and other information. So we basically pull wires between the tanks, and invariably, whenever we do it at night, and we'd then pull away, we'd forget to disconnect the cables, and all the cables would get wrapped up in the treads, and it would basically become a total nightmare. And the point being, it's really smart to game everything, rehearse it, turn it into a fun game with flexibility. There are no rules, meaning, as you said, situations are fluid. Every situation is going to be different, but everything's hackable, nothing's secure. Game it, and then be flexible about the future.
I would say don't over-engineer a program. Develop something that's right size for your company and for your portfolio companies, and definitely rely on trustworthy third parties to provide guidance and support.
Okay. Well, do we have any questions? We have about 30 seconds left, sir.
Mahesh Saladi, I started my PE career in 1989. So over the period, there is so much of change. One of the questions I would like to ask, lower and mid-market firms with the portfolio companies, around and very little staff and not too much of budget apportioned to that. Do you keep a centralized cyber security system, or do you really individually do that? The reason I'm asking this is they're all on different platforms and different software systems. How do you really keep control and monitor it on a standard basis?
Yeah, so Riverside's portfolio companies really do operate independently. What we have centralized is the evaluation of the risk. And then that information is transferred to our operating teams, who then work very closely with our management teams and boards to help analyze that, evaluate it within the company, and then determine what kind of remediation strategies they're going to implement. We are not monitoring any kind of technical solutions. We're not aggregating logs at a parent level. Our companies run independently.
Any other questions?
You had mentioned that the courts were split on not showing damages, but whether just loss of data itself is profitable or not. What happens though, or what's the time frame you're seeing between the time point that the data is stolen to the time point that it's sold and something does happen? Because these cases probably close, and then there's still risk out there. What are you seeing?
Right. I mean, so that's always a challenge for a plaintiff's lawyer, right? Is the timing. I mean, on the one hand, if it's a potential class action, the typical way that it goes is you want to be the first to
One of
file.
the first to file, if not the first.
Yeah, because then you're going to be appointed class counsel, and then they do an amended complaint. So.
But that provides fodder then for a motion to dismiss on standing grounds, on lack of causation, lack of
Right.
damages. So there's a delicate balance there.
Yeah, but so typically they're going to try and file right away, even though they haven't had the opportunity to show really concrete damages yet, and maybe hopefully it will string along a while and there'll be some concrete damage. And that's why I think in the initial complaint, before it's even been amended, they'll say something like the named plaintiff had to buy credit monitoring services or something like that.
Any others? Well, great. I've really enjoyed this. I've enjoyed moderating this panel with all of you, very, very fine gentlemen and experts in the field, and thank you all very, very much.